contemplated in Kyoto Holohan will not apply. Now, having referred the matter to a larger bench, we have given our reasons for coming to the conclusion that we are still dealing with the matter on merits because Nabam Rebia, strictly speaking, did not arise in the matter before us, but we thought Nabam, the controversy, should be settled by a reference to 7 judges. So I'll now go to the what we have said on the merits of this particular case. The House of the People and the legislative assemblies of states are constituted of members directly elected by the electorate. The candidate who secures the highest number of votes is returned to the assembly. The political party forms government. A coalition of political parties may form the government if no single political party reaches the halfway mark. Articles 75 and 164 provide that the Council of Ministers is collectively responsible to the House of People and the Legislative Assembly of the state, respectively. The legislators who are directly elected by the people have a duty to hold the executive accountable on the floor of the House. Legislative procedures serve 2 objectives. First, they enable deliberation and discussion on the floor of the House to hold the executive accountable, and such deliberation also produces better constitutional outcomes. And second, they create a system to place a check on the exercise of power by the incumbent government. Certain procedural requirements prescribed by the Constitution safeguard constitutional values. This is reflected in Article 368, which prescribes a special majority to amend certain constitutional provisions, which, according to the members of the Constituent Assembly, hold a higher constitutional and democratic value. Certain other legislative procedures further democratic processes and accountability and prevent the concentration of power in the hands of the incumbent government. Article 212 cannot be interpreted as placing all procedural infringements beyond the pale of judicial review. Such an interpretation would completely disregard the importance of legislative processes in a constitutional democracy. Now, we have dealt with the whip as to whether the whip is really a whip appointed by the legislature party or by the political party. And we say to hold that it is the legislature party which appoints the whip would be to sever the figurative umbilical cord which connects a member of the House to the political party. It would mean that legislators can rely on the political party for the purpose of setting them up for election, that their campaign would be based on the strengths and weaknesses of the political party and its promises and policies, that they could appeal to the voters on the basis of their affiliation with the party, but that they can later disconnect themselves entirely from that very party and be able to function as a group of MLAs which no longer owes even a hint of allegiance to the political party. This is not the system of governance that is envisaged by the Constitution. In fact, the 10th schedule guards against precisely this outcome. That a whip be appointed by the political party is crucial for the sustenance of the 10th schedule. The entire structure of the 10th schedule, which is built on political parties, would crumble if this requirement is not complied with. It would render the provisions of the 10th schedule odious and have wider ramifications for the democratic fabric of this country. Thus, the courts cannot be excluded by Article 212 from inquiring into the validity of the action of the Speaker in recognizing the whip. On 25 November 2019, a meeting with the newly elected MLAs belonging to the Shiv Sena was chaired by Mr. Uddhav Thackeray in his capacity as the Shiv Sena president, party president, Paksh Pramukh. The resolution notes that the MLAs unanimously resolved that all decisions in the meeting would be taken by Mr. Thackeray. A resolution was issued appointing Mr. Eknath Shinde as the group leader of the SSLP and Mr. Sunil Prabhu as the chief whip. On 21 June 2022, some members of the SSLP held a meeting under the chairmanship of the president of the Shiv Sena, Mr. Uddhav Thackeray. In the meeting, it was resolved to remove Mr. Shinde as the group leader of the SSLP and appoint Mr. Ajay Chaudhary. The resolution was signed by Mr. Uddhav Thackeray in his capacity as the president of the party on the official letterhead of the office of the SSLP. Then, having dealt with that, we say the Speaker was aware of the emergence of two factions in the legislative party on 3 July 2022 when he appointed a new whip and a new leader, because the resolution of the respondents specifically mentions that a split had occurred due to prevailing dissatisfaction in some MLAs of the Shiv Sena. Further, the fact that there were two resolutions appointing two different whips and two different leaders would no doubt have resulted in the speaker inferring that there were two factions of the Shiv Sena. The speaker, on taking cognizance of the resolution passed by the faction of the SSLP led by Mr. Shinde, did not attempt to identify which of the two persons who were nominated, namely Mr. Prabhu or Mr. Gogaole, were authorized by the political party. In a contentious situation such as this, the speaker should have conducted an independent inquiry based on the rules and regulations of the political party to identify the whip authorized by the Shiv Sena political party. For the reasons detailed in the preceding paragraphs, the speaker must only recognize the whip appointed by the political party. The decision of the speaker recognizing Mr. Gogaole as the chief whip of the Shiv Sena is illegal because the recognition was based on the resolution of a faction of the Shiv Sena legislature party without undertaking an exercise to determine if it was the decision of the political party. Harmonizing the 10th schedule with paragraph 15 of the symbols order. This court cannot accept the solution proposed by the petitioners and lay down a constitutional sequence. To hold that the Election Commission of India is barred from adjudicating petitions under paragraph 15 of the symbols order until the final adjudication of the disqualification petitions under the 10th schedule would be in effect to indefinitely stay the proceedings before the election.
आपको बता दें सुप्रीम कोर्ट में फिलहाल सेना बनाम सेना का जो मामला है वो चल रहा है। आज उस पर बड़ा फैसला आना संभावित है। लाइव स्ट्रीमिंग चल रही है और हमारे सहयोगी अभिषेक इस वक्त हमारे साथ जुड़ गए और ज्यादा अपडेट लेकर। अभिषेक, लगातार जो है कि वो सुनवाई चल रही है, कुछ बड़े ऑब्जर्वेशन भी कोर्ट द्वारा, जब चीफ जस्टिस जो हैं वो चंद्रचूड़ चीफ जस्टिस हमारे वो कॉपी जो पढ़ रहे हैं उसमें कई मुख्य बातें अहम सामने निकल कर आई है। दर्शकों के लिए वो उन बातों को
जाहिर तौर पर जिस तरीके से जो सबसे पहली बात आई है, जो नेबाम राबिया जजमेंट की बात की जा रही है और इसे लार्जर बेंच को रेफर कर दिया है। कहीं ना कहीं मैं दर्शकों को बताना चाहता हूँ, ये वही मांग है जो उद्धव खेमे द्वारा पहले भी चीफ जस्टिस के सामने रखी गई थी और उन्होंने ये कहा था कि जो नबीम राबिया जजमेंट है उसे लार्जर बेंच को दिया जाए। और वो जजमेंट क्या है वो भी मैं बताना चाहता हूँ। वो जजमेंट इस तरीके का है कि अगर कोई स्पीकर या डिप्टी स्पीकर के खिलाफ अगर अविश्वास प्रस्ताव रखा गया है तो वो कैसे निलंबन प्रस्ताव पर डिसीजन ले सकता है। तो ये जो जजमेंट है उसको लार्जर बेंच में भेजा जाएगा और कहीं ना कहीं इसके दो मायने हैं कि अभी जो निर्णय अभी भी आप देख रहे हैं जिस तरीके से चीफ जस्टिस निर्णय पढ़ रहे हैं, अभी जो वो कह रहे हैं कि जो केस के रिलेटेड बैकग्राउंड है, जो मुख्य पहलू है, किस जो जैसे कहें स्पीकर, डिप्टी स्पीकर, गवर्नर, इनका रोल है और उसके बैकग्राउंड को लेकर वो टिप्पणियां कर रहे हैं। कहीं ना कहीं जो सबसे बड़ी एक चीज अगर हम देखें कि जो नबीम राबिया जजमेंट है जिसको लेकर शिंदे गट अक्सर अपना रिप्रेजेंटेशन और आर्गुमेंट रखता था कि एक वो स्पीकर किस तरीके से निर्णय ले सकता है जिसके खिलाफ खुद अविश्वास प्रस्ताव है, और ये जो जजमेंट है उसको चैलेंज किया था। कहीं ना कहीं उसको लार्जर बेंच को रेफर करने की मांग उस समय चीफ जस्टिस ने ये साफ कह दिया था कि फिलहाल इसको लार्जर बेंच में भेजने के लिए हम सहमत नहीं है, बट जब हम केस सुनेंगे, आर्ग्यूमेंट सुनेंगे, उसके बाद अगर हमको लगता है इसे भेजना चाहिए तो हम भेजेंगे। तो जो आज एक बड़ा निर्णय आया है, कहीं ना कहीं इससे एक चीज तो साबित हो रही है कि फिलहाल जो निलंबन का फैसला है एकनाथ शिंदे का है या फिर बागी विधायक जो थे 16 विधायकों का, फिलहाल नहीं होता दिख रहा है। अभी जो चीफ जस्टिस कह रहे हैं वो तमाम जो रोल अदा किए गए हैं स्पीकर द्वारा, डिप्टी स्पीकर द्वारा, गवर्नर द्वारा और पूरे केस का बैकग्राउंड की टिप्पणी कर रहे हैं। लेकिन एक कहीं ना कहीं एक मांग जो उद्धव गट के द्वारा की गई थी कि इसे लार्जर बेंच पर भेजा जाए, वहां सहमति बनती दिख रही है और साथ ही साथ एक राहत की सांस एकनाथ शिंदे और उनके बागी विधायकों को भी मिलती दिखाई दे रही है, क्योंकि अगर क्योंकि ये रेफर कर दिया गया है तो अब ये सात जज की संवैधानिक बेंच इसे से सुनेगी और उसके बाद उस पर फैसला आया जाएगा।
बिल्कुल।
तो जो स्पीकर है जिसके खिलाफ अविश्वास प्रस्ताव है, क्या वो
बिल्कुल अभिषेक, आपका बहुत बहुत शुक्रिया इन तमाम जानकारी के लिए। तो लाइव स्ट्रीमिंग चल रही थी, सुप्रीम कोर्ट में बड़ा फैसला आने वाला है। आपको बता दें, फिलहाल जो ऑब्जर्वेशन है वो धीरे धीरे करके आ रहा है और हम आप तक पहुंचा रहे हैं। बढ़ेंगे एक और बड़ी खबर की तरफ।